Well, good morning, everybody. Welcome to our webinar this morning, which is all about the effects of COVID-19 and the pandemic on family matters. I'm delighted to be joined this morning by Sarah Dowie, who's Associate Solicitor and part of our family team here at Palmers. Welcome, Sarah. For those of you that are used to using Zoom, you'll hopefully be familiar with the Q&A tool on your toolbar. So we'll have a live Q&A at the end of this webinar. So if you'd like to ask Sarah any questions, please use that tool to post your questions in, and we'll try and answer as many of those live before we get to the end of the webinar today. We are recording this as well, so if there's any points that you want to go back over afterwards, then we'll have a on-demand version of the webinar available later on the website today. Okay, so I'm going to hand over to Sarah at this point, and I shall see you at the end for the Q&A. So over to you, please, Sarah.
Good morning. My name is Sarah Dowie, and I am a family solicitor based at our Raleigh office. This morning, I'm going to be talking to you in a bit more depth about the effect on families of the COVID-19 pandemic. May I have the next slide, please? Firstly, can I just apologise for me having to invoke my inner Chris Whitty or Patrick Vallance by having to use the term next slide, as Jo is helping me with that part of the webinar. Okay, so one of the first questions that I'm often asked about parents after the first lockdown was what would happen in respect of contact arrangements. I think initially lots of people were very confused about whether arrangements that they had by way of a court order or informal arrangements that had been agreed between family members could actually continue. But we were very lucky that very early on the Children and Family Court Advisory Support Service issued guidance and made it very clear that actually you are not breaking the social distancing rules if you allow a child to move between, for example, mum and dad for their usual spend time with arrangements. And this was actually then quickly backed up by a very senior family judge who made it very clear that parents can allow children to continue moving from one household to another. Now, having said that, every household is able to make decisions for itself, in that you might have a household that's got a particularly vulnerable householder, and parents can then have a discussion about that, work out what the safest arrangements are for both households. And for some families, that might mean suspending those arrangements, which you need to be doing by agreement in most cases. And where you do agree, you should do that by recording it. That can be an email or a text message or a note with the two of you agree that sets out what the new arrangements might be. In some circumstances, parents are going to be able to reach agreement, and if a parent considers that it's not safe for them or one of their householders to allow the contact to continue taking place, they may decide to suspend those arrangements. And again, in circumstances where that's being done, you should record that and be mindful that the other party might apply to court, and the court might then review that decision and may not necessarily agree that the parent stopping that contact, that spend time with, was actually the right course of action. So do be thinking about that if you or any of your family members are struggling with those sorts of issues at the moment. What I would say is that lots of parents will be able to sort this out very effectively between themselves. You know, I see a very limited number of people, and if you do need assistance, come and get it early before any problems arise, because that often means being prepared for any eventualities and any difficulties. I would also say that if a person is having any difficulties around child maintenance, sometimes we're finding that the paying parent isn't able to continue paying anymore because they're on sick pay or they are on furlough. And what the Child Maintenance Service has said is if you can't afford to pay, you can reduce your payments. Of course, you should be letting the other party know. But on the flip side, the Child Maintenance Service was saying to the receiving parent, well, don't contact us at the initial start of the lockdown because we're not contacting parents who are paying. And of course, that creates hardship because everybody's got to make sure that they can plan financially. So again, discussing matters is really the best thing for parents, and where you can't get assistance, and often my clients are reporting to me they can't get through to the Child Maintenance Service, try to reach agreement with the other party and use other methods such as instructing a solicitor or mediation, which I'm going to come on to next. In terms of childcare bubbles, these have been deemed by government to be able to continue, so that families with those caring responsibilities can meet that caring need, but that's applicable to children aged 14 or under. And I can see the government has really tried to look at a new way of assisting families in trying to meet their caring responsibilities. And I think that's going to affect a lot of grandparents, and it may be that there's some grandparents listening to this webinar. May I have the next slide, please? Apologies, everybody. Didn't get the next slide moved on at the right point. I'll just give you a moment if you want to just have a look at that, and then we'll move on to the next one. Next slide, please. No, sorry, domestic violence, you're there for me. Thank you, Joe. Apologies. Okay, so quite soon after the introduction of the first lockdown in March, it became that the long periods of isolation were in fact leading to increased levels of domestic violence. So there's been some research published by the BBC Panorama programme. You may all be familiar with that. And they did that in collaboration with a charity called Women's Aid, which specifically specialises in helping women who are victims of domestic violence. What that showed is that 2/3 of women in an abusive relationship have reported having suffered more violence during the pandemic, which is a pretty alarming statistic, really. What we've also discovered is that three quarters have said that it has, of those are really hard to escape that violence whilst they're in a lockdown. I'm having to stay home, you all listening are having to stay home, and if you've got a very difficult home life, there isn't much places for you to go and seek refuge from that. And what they were saying is that over 9 out of 10 of those respondents said that the pandemic had really negatively impacted on them in at least one way. So there is also an issue for men that are victims of domestic violence, and the charity that looks after men is called Respect, and they have seen a 65% increase in men having to access their assistance on their inquiry advice line. So it's obviously a really quite difficult situation for anybody that's been a victim of domestic violence. In particular, women often find that they are marginalised together with ethnic minorities and migrant groups and disabled women. So again, if you've got any friends or family or yourself who have been affected by any of these sort of difficult issues, really important to get advice as early as possible, because for some people they have to plan their escape, and that's not something that they can do very, very quickly. So I'm very pleased to be able to tell you that in Parliament we have a landmark domestic abuse bill, and that is going to establish a new statutory definition of domestic abuse. And it will emphasise really that it's not just violence. I have had many clients come to see me about coercive control, about financial control, or even just psychological abuse and bullying, and some people don't recognise the non-violent elements as being domestic abuse. So I think that this bill will really help to raise awareness for victims about what's happening, and ensure that they have the legal channels to be able to challenge that behaviour. In particular, it is going to stop perpetrators from being able to cross-examine their victims in the family court, which at present they can do. I'm pleased that usually where one party who says they're a victim says to the court, look, I can't deal with this person cross-examining me, that's often listened to, and the court will often put other safeguards in place, allowing the judge or the magistrates to take that questioning. But I think that it's still a very daunting process for victims of domestic violence to even be worried that that might be a feature. And so once that bill comes in, they'll be alleviated of that if they're in an English or Welsh court. The government has recognised that it's a difficult time for victims of domestic violence, and in doing so actually has made it very clear that victims of domestic violence can leave their home to seek support, irrespective of the social distancing measures. So refuges are open, and the police have confirmed also that they will be helping to support any individuals that have been abused, and that's, as I say, physical, emotional, or any other type of abuse. So if anybody's in that situation, they can find the support. They usually end up in self-contained accommodation, and they can isolate there, and they can seek necessary support and advice that they need. And of course, in terms of what I can assist victims of domestic violence with, they can think about considering the pursuit of a non-molestation order. That is an order that is used to stop the violence and the harassing behaviour. And in respect of property, they can apply for an occupation order, and that is to stop the other party from returning to the home, or asking them to leave and telling them that they're not able to actually come back. The NSPCC, which is the National Society for the Prevention of Cruelty to Children, has also reported an increase in calls of nearly 50% regarding domestic violence since the lockdown, which again is a massive increase, and really to show the pressures that are on families at the moment. I was quite interested to learn that the pandemic has actually increased the risk of domestic violence quite a lot for older people, because I think that people often imagine that this is something that affects younger families, but I certainly have had a range of clients in my experience, and all sorts of ages, and men and women who are victims of domestic violence. Really what we find is, if you're older, you tend to be more reliant on the perpetrator for financial matters, or possibly for their care, and that can make it very difficult to try and escape that. There could be all sorts of barriers as well. It could be, if you're older, there's the lack of being physically well enough or having mental capacity to actually access the help that's out there at the moment, which has been improved, which is digital access and other services. So we just have to be very mindful that there are those hard to reach individuals, and just making sure that they're able to access help where they need to. Next slide, please. Okay, in terms of divorce, it's been the case that since the last lockdown, there's actually been an increase year on year since the last lockdown for the same period. Now, most people do find that divorce is not a decision that they make lightly or easily. That they're worried about their children, they're worried about their financial situation, what might happen to their employment because they're not living together anymore, etc., etc. But ultimately, the pandemic has placed an enormous strain on families, and certainly what I found is that the relationships that were struggling already found that the lockdown was the straw that broke the camel's back. And I certainly saw, once the lockdown began to ease, and as early as April, people seeking advice about their relationship having broken down. When I give people advice, sometimes that advice, when they're speaking to me, is that they might want to consider reconciliation, because some people come and get advice from me really early, which I recommend, but it means they haven't always made the decision about bringing the relationship to an end. And people don't take these decisions lightly, but ultimately, if you do find yourself in that scenario, then you are seeking a divorce to formalise what you consider to be the end of the relationship. Divorce isn't for everybody, and for those couples that, for whatever reason it might be, they want to delay their divorce or religious reasons, they might actually prefer to have a separation agreement. Next slide, please. So a separation agreement, next slide, please. It is also known as a deed of separation, and this is what couples use when they, as I say, don't want to divorce straight away, or they don't want to divorce at all. What this document does is it allows those individuals to record what the issues are arising out of their separation, set down their agreement, and they can then continue to live separately. And later on, if they choose to divorce, they've got a document that's recorded, what their agreement is about things like the divorce, the financial arrangements. Could be that the home is going to be transferred from one party to the other or sold. What might be happening about payments of maintenance from one party to the other. And you can also record in that what the parties think they might like to do in respect of their children, and what the arrangements for the children might actually be. So it's quite important to recognise that the separation agreement can be recognised by the courts. It does give you some certainty and a vehicle for progressing at a later date to what is called a financial consent order within divorce matters. In terms of the courts, unfortunately, COVID-19 has led to very significant delays in the court system and the conclusion of proceedings, and I would suggest that that is another reason why somebody might be considering using a separation agreement, because it gives you a document that you can refer to until such time as you can conclude matters by way of a court hearing. For lots of couples that are going through relationship breakdown, it's very, very stressful. And of course, having a document that records what you've agreed can sometimes alleviate that distress. Next slide, please. In terms of prenuptial agreements, they are very popular, and I think that it's right to say that it's because it provides security, and it's a practical solution in terms of you forecasting that you want to be able to refer to a document, set out what you agree, and know that you can just then move forward without the stress and the acrimony that relationship breakdown can bring when you're trying to settle financial matters. They're not just for the rich and famous. They are really for anybody who is coming to a marriage with assets, and they want to protect them. I've had people who perhaps might just be placing a larger deposit than the other party on their family home, and they just want to protect that in some way. And having these frank conversations early on in the relationship are often very useful and welcomed by the other party. I know that as Brits, we often don't talk about these sorts of things, but certainly my clients have found it very helpful to have such a document that records what they've agreed and how they will settle things if the relationship breaks down. And I'd like to say that it's not necessarily a forecast that the relationship is going to break down. I am anecdotally convinced that some of my clients remain together because they have these sometimes embarrassing or perhaps difficult conversations at the start of their relationship, meaning that they've laid some good foundations for going forward. Next slide, please. So I qualified in 2008, and I know that the non-fault divorce has been something that we have desired in the world of family law for many years, and at the moment it's not yet law. You have to establish one of 5 reasons for a divorce. 2 of them are based on separation, and that'll be your 2-year separation with the other party's consent, or 5-year separation without consent. Otherwise, you essentially have to blame the other party. So it might be their unreasonable behaviour, or that they have deserted the other party for a couple of years, or adultery. And blaming someone for a divorce can often increase the acrimony and make things quite difficult. So having a non-fault divorce will really alleviate a lot of that. It's due to be introduced in the autumn of 2021, but I am concerned that, given the government obviously is very busy dealing with the pandemic, that it may not come into force later this year. And it is very much needed, because many of my clients will express to me that, you know, their relationship has just broken down because they've either changed as individuals, or they've grown apart and they don't want to blame the other party, and it leaves people in a very difficult situation where they are forced really to blame the other party, so that they can get their divorce quickly and move on. Unfortunately, at the moment, divorces at our local divorce centre are taking 12 to 18 months to complete, and that really is just due to initially volume, but subsequently the pandemic causing more delays. Here at Palmers, we make use of other divorce centres that have shorter waiting times, so that we can try to deliver something there for our clients. And where we can use the online service, we certainly do, because that's a much quicker turnaround for divorce as well. Next slide, please. Mediation. It's either going to work or it isn't, is what I will say. It does work for so many couples. Lots of my clients have already been to mediation when they come to see me, meaning that they are telling me what is agreed, or they haven't quite tied up every loose end. And between myself or a mediator, we do that and then progress to setting it out in an agreement, be it separation or financial consent order. You know, at the moment, mediators are actually able to assist. They're doing things virtually. Some are doing them by telephone, some are doing them by video conferencing. Not many are doing face-to-face, certainly at the moment, because of the pandemic, but parties shouldn't be discouraged from mediating just because of the pandemic. It's still available, and it can be a very useful tool. Timing is everything, I would say, with mediation, because parties have to be ready to reach agreement and ready to negotiate, because mediation, it really is a compromise. Next slide, please. Okay, so in terms of financial hardship, really it's resulted in some parties not being able to pay the level of spousal maintenance that they may have been ordered to pay a year ago, 5 years ago, 10 years ago, whatever it might be. And in circumstances where you can't afford to pay because you might have been furloughed, or had to take a pay cut, possibly even made redundant, those orders can be reviewed. Now, if you can't afford to pay, you are required to continue paying until you obtain the agreement of the other party not to pay, or the court releases you from your requirement to pay. Now, again, if you're going to agree with the other party that you're going to reduce the payment downwards, this really should be recorded in an email, and preferably in a consent order, where you are recognising that that downward payment is no longer going to take place. Because if you've got a court order saying that you should be paying, for example, £5 a month, and you're only paying £1 a month, you get £1 per month, you really should have a court order, new one, that says that it's going to be £1 per month. Unfortunately, you've got competing interests here. You'll probably have the person who's paying saying, look, I need to reduce those payments, and possibly the person who's receiving those payments saying, well, I don't agree, I need that money, you're going to have to find it from somewhere else. If that is the case, legal advice should be sought early before problems develop. There's certainly no ostrich-like situations where a person is burying their head in the sand, because the problem will continue to snowball. Some early advice. Mediation, again, is available for those parties that might want to have a discussion around what they can and can't afford. And, you know, arbitration may also be helpful to deal with those disputes. And then as a last resort, if you really can't agree, then a court application is going to become necessary to ask the court to reduce those payments. What I would say is that it's really important to bear in mind that the global emergency that we're in at the moment should not be used as an excuse by the person who's paying for a payment holiday or to force a downward variation. And what I can say to you is that anybody that is attempting to do that is probably going to find that the cloak will be pulled off by the court at the stage of any court application to deal with that. I'll just say a little bit about arbitration, as I mentioned it there. It's essentially like a private court process, and you can both parties can instruct solicitors, and then we would take your matter to an arbitrator who acts as a judge, and will give you a binding decision. Next slide, please. Well, that pretty much concludes my webinar on the difficulties that families face during the pandemic of COVID-19. If you do need any advice on matters such as divorce, separation, finances around separating, cohabiting couples, prenuptial agreements, domestic violence, or matters relating to children, my contact details are on the screen, and you can telephone my paralegal, whose name is Jessica Lacey, on that telephone number. It's 01268 988 488 for the purposes of seeking an initial fixed fee meeting with me, where I can discuss a matter in more depth and obviously give bespoke advice. If you've got any questions, I can deal with those now.
That's great. Thanks very much, Sarah. Very informative. There are a couple of questions that have come in actually in relation to arbitration. So I'll put them both in front of you. First of all, is arbitration quicker than a court application? And what sort of matters can arbitration be used for?
So in terms of family matters, you can use arbitration for financial matters as a divorcing couple. So it might be that, you know, you can't quite decide, you know, how you're going to split up the house and whether or not it should be sold. And you can use arbitration for that sort of matter. You can use it for children as well. And actually at the moment and prior to the pandemic, arbitration was really the quicker way of resolving matters. I obviously spoke earlier about the very significant delays in the court system at the moment. It's horrendous, quite frankly, when it comes to children matters. Some of my clients are waiting 4 months to get their first hearing, and if you're not seeing a child, that is far too long. And what arbitration can offer is that private hearing. And usually I find that once you've identified an arbitrator, they are willing to hear your matter within 14 days. It very much mimics the court process. You know, you can then get through things quicker, and once you've got a decision, you can apply to court so that you've got a binding order at the end of it. And the arbitration process itself is still binding, but in terms of what people are used to, they prefer to have the type of order that you'd have if you applied to court.
Okay, and one other question here about, you talked about prenuptial agreements. Somebody here, can you do a post-nuptial agreement, and do they stand up in court?
Yes, you can do a post-nuptial agreement. They do not carry as much weight as prenuptial agreements, but that certainly shouldn't be a reason not to enter one, particularly if you're looking to protect a significant amount of assets. And again, what the court likes to see is parties seeking independent legal advice. You don't have to worry about being seen as rushing or coercing the other party into a post-nuptial agreement because you've already married. So you have that on your side. And you know, in terms of post-nuptial agreements, the court's view is that they like to find out what the intentions of the parties were, making sure that it's fair. And again, if you know, instead of saying, "Oh, it's all mine and you're never going to get anything," if you do something that's fair, then the chances of your post-nuptial agreement being upheld by the court increases.
Okay. And we've got time for one final question. How much of the divorce proceedings can be done online?
Well, at the moment, I'm very pleased to say that where you've got a straightforward divorce, and I'll say to you that is probably 98% of the divorces that I deal with, you can do it online. If you've got something that's more complicated, like an annulment, which is very rare, or what we call defended divorce proceedings, where the other party is actually saying, no, I don't want a divorce on that basis, i.e. adultery, because I didn't commit adultery. That's rare too. So most of my clients can benefit from use of the online service.
Fantastic. Okay, well, look, that brings us up to 11 o'clock. We have answered all the questions, so thank you very much, Sarah, for the presentation. As I said earlier on, we have recorded this webinar, so we will make a copy available on the website later on today. And if you've got any further questions, please don't hesitate to contact Sarah by email, which is on the screen at the moment, or of course, just pick up the phone. Thanks very much, Sarah.
You're welcome. Thank you, everybody. Good morning.